episode of Getting Down to Business with your boy, financial lifestyle planner Sean Bailey. You're listening to us on 108praiseradio.com, voice in the gospel. And again, you could be doing anything this evening, anything in the world, but you choose to listen to me. And for that, I greatly appreciate you, and I'm blessed for it. Tonight, I'm so excited because I got a good guy in here with me tonight. We've been doing some partnership type things together.
Yes.
And his name is Mr. Duron Tucker. Welcome, Mr. Duron.
Thank you, Sean. Pleasure to be on, and thank you for inviting me.
Oh, pleasure's all mine. Now, Duron, I can't do it, so tell the people a little bit about yourself.
Okay, well, I'm a practicing attorney in the Atlanta metro area. I've been practicing law for 20 years, and my primary area of concentration in the law is estate planning. So,
Okay.
estate planning, wills, trust, powers of attorney, advanced medical directives, all the things that go into allowing someone to protect their legacy moving forward in terms of how they distribute their property.
Awesome. Well, the reason I wanted to have Duron on tonight is because a lot of people get it misconstrued when it comes to wills and trust, and I really want to talk about the subject tonight because I feel it's essential that if you own anything, or if you have, and I always say this, people say, well, if I don't have anything, but if you have anything of value or anything of trust or love to you, that you want to leave to your loved ones, wills and trust, these things come into play. And not only that, advanced medical, which we'll talk about a little bit later. But tell a little bit to people a little about you. Are you from here in Georgia?
Originally from New York.
That's why I
And,
love them. That's why I love them.
and the family, we moved down to Atlanta 6 years ago.
Okay.
Yes,
All right. Awesome.
2011.
Awesome. And your practice is right here in Atlanta, or?
That is correct. In Kennesaw.
Okay.
Yes.
Well, again, everybody, I'm really excited about this information because I feel this is very, very valuable information. So hold on, because here we go. So, first of all, let's start out, Duron. What is a will?
Well, a will is simply, Sean, a legal written document that sets forth your directions as to how you wish to divide your property, your real property, and your personal property.
Okay.
So when we talk about real property, we're talking about land, or for example, your home or houses that you own. We talk about personal property, we're talking about everything else. It's not land or a house. So any tangible personal property, clothing, furniture, bank accounts, for example, these types of things.
Jewelry.
Appliances, jewelry, collectibles, any
Yeah.
valuables of that nature that are tangible to your personal property.
Okay.
That's what you're talking about, that's placed in a will. And
So-
also, with the will, the important thing about a will is that a will is your last opportunity to declare legally how you wish to divide your assets, your real property and personal property when you pass away. So very important.
Okay, so speaking about a will, so does that have to be something that's down in writing, or could it be like recorded? These are my last wishes. Like, how does that work?
Well, a will, according to Georgia law, a will must be in writing, and it must be signed by the person making the will. Or if it's not signed by the person making the will, it must be signed by someone else at the direction, okay, of the person who's making the will.
So, like a power of attorney.
Not so much a power of attorney, but let's say, for example, you were not able to articulate your wishes, or say you weren't able to sign the will, for example. And let's say, for example, it's my will. I directed you to sign the will, but if you signed for me, it's best that you do this in front of two witnesses who would attest to your signature and attest that the will is being signed by you. Or in the case of say, for example, you're not able to read, then the will would have to be read for you by two witnesses
Okay.
who would then attest by their signature that the will was read for you.
Okay.
Yes.
That's awesome. So, this is who do you think is ideal for a will? Who do you think should have a will?
I think anyone who has anything of value to that they want to leave behind to their loved ones after they pass away should have a will.
Okay.
Whoever that may be, whatever your age, whatever your background is, because the key is protecting that legacy. And I talk to people all the time about the fact that it's really a shame that you could work for 5 years, 20 years, 30 years, 40 years even, and accumulate a great deal of wealth, a great deal of assets that you work very hard to attain. And then you pass away without making an estate plan, and you have no control at that point as to how your hard-earned assets are going to be divided amongst your loved ones. And that, to me, is a huge shame.
Okay. So let me ask you this. So let's just say somebody doesn't have a will, and they own property in the state of Georgia and this lovely state of New York, where we're from,
Okay.
and they pass away, and they have children, they have a wife, but they didn't have a will. They have property in their name and valuables in their name,
Yes.
and they pass away, what happens to the house here in Georgia? What happens to the house? Does that just go to their children and their wife?
Well, as long as you have a relative that is able to receive your property when you pass away,
Mm-hmm.
there's a structure in Georgia. It's called the laws of intestacy. There's actually a statute in place that determines exactly how the property will pass. So let's say, for example, again, as you mentioned, the person dies without a will. Okay,
Mm-hmm.
they've got a spouse, they've got children, they've got valuables. Well, there's an order in that statute that determines how the property is going to be divided. So the order goes as follows: you have your spouse, okay, then you have your children, okay, then you have behind that you have your parents, and then you have your siblings.
Okay.
Behind them you have your grandparents, and then you have your aunts and uncles, and then you have your first cousins, and then you have your other relatives. So you have 8 degrees that they go through. So if as soon as you get past one level, say you don't have a spouse, now you go to the children, and they receive the property. No children, now you go to the parents if the parents are alive, and on down the line to distribute the property. Now, one might say, well, I died without a will, and there's a statute in place where the property is going to pass. Why should I worry about it? Well, the key is, even though you do have that plan in place by statute, that may not be what you intended. So let's take Prince, for example. Prince passed without a will.
I'm so sorry. Like, that was the most
Yeah.
mind-boggling thing. But when somebody told me, when you deal with people that, and I know you deal with a lot of people in the music industry,
That's
I think
correct.
you told me this.
Yes.
When you deal
yes.
with a creative person,
Yes.
it's hard to get them to stop being creative and
That's
actually
correct.
handle business.
That's
So
correct.
I was like, but really? You was like, yeah, really.
That's correct. And the fact of the matter is, Sean, is that even though, things ultimately turned out where certain family members were able to divide the estate, we'll never know whether Prince intended for it to be that way. That's not disparaging anyone who collected. Obviously, his family deserves the property.
Mm-hmm.
But if Prince had decided to make a will and estate plan, he could have determined for himself exactly the manner in which he wanted the assets to pass. And because he didn't have an estate plan or will in place, his intentions may not have been met, and we'll never know whether what happened was what he actually intended.
Okay, so let me ask you a question. So now we'll use Prince for instance. Prince has a will.
Yes.
Let's just say he has a will here in the state of Georgia.
Okay.
And his will says, I leave all my property and my possessions to my daughter. Well, he didn't have any children, but to his sister.
Okay.
What is the next process? She just shows up with the will, everything's transferred over into her name and said and done? What
No,
happens next?
no. What happens is, okay, he's got the will. His sister, in all likelihood, is named as the executor, or even if she's not, in your example, she's left the property. What happens then is, after Prince passed away, it's a system and a process called probate. And probate is a process by which you take that finished will and you quote-unquote administer the property. When we talk about administering property, what we're talking about is taking, paying the taxes on the estate, paying any debts that the state has, and then having the executor distribute that property to the people who are entitled to receive under the will. In your example, the sister. So that
Okay.
process is called probate.
Okay.
Yes.
So another question I had, and I wanted to try to, because I'm thinking about it, I wanted to get it out. So let's just say you have a gentleman, let's just say Prince was married,
Okay.
got a divorce, and then he got married again,
Okay.
has no will.
Okay.
How does the ex-spouse, it doesn't have to, well, we're using a male, but the ex-spouse, is the ex-spouse included in, if there's no will, can she make a claim against the estate?
No, not the ex-spouse, but of course the spouse who he's married to at the time he passed away. She now is the person in line under the statute we talked about in intestacy if he didn't have a will.
And what about children? What if he has children with the current spouse and with the former spouse? What do
Right.
the children play into that?
Well, the children in that case would inherit as his children. But it's an interesting thing that you mentioned regarding that. Because if you talk about a person who passed without a will, you have a nuance there. Because children, let's say for example, are we talking about born out of wedlock or born in wedlock? If they're born in wedlock, then they're going to inherit anyway
Okay.
under the statute.
And if they're born out of wedlock?
Now, out of wedlock is where the nuance occurs. If you have a child who's born out of wedlock, they're entitled by law to recover from the mother or the mother's line, okay, in terms of her estate. But if it's the father or the father's line, the child will not inherit from the father or the father's line unless there's clear and convincing evidence that that child is the child of the father. And that has to be shown by certain things, and pretty much you can show it in a few ways. It could be a court order establishing legitimacy of the child. It could be a court order establishing paternity of the child. It could be the father signs a sworn statement that he is the father of the child, or very basic way would be for the father to sign a birth certificate. But unless you have that kind of clear and convincing evidence in place, without a will, that child may not be able to inherit from the father's line.
Wow. So
Yes,
basically,
wedlock.
so another thing is because we're talking about that a lot, and
Yeah.
I know you have it's kind of like a package that you have because you when we were talking about it, you
Yes.
kind of explained it to me. When somebody gets a will from you, they get more than just a will, correct?
That's correct. That's
what
correct.
what all comes? So if I come to you, Deron, and I say, look, and I think we talked about this. We're meeting next week, so we
Yes.
can make sure that I got everything in order. We meet and we sit down. When I sign up and I purchase a package to get my will done with you, what all comes with that?
Okay, glad you asked that question, Sean. Well, I offer a will package, and I believe it's very important because you have to be thorough when you deal with clientele, and you want to try to come up with an estate plan that really suits their needs. That's why I think the package is very important. So my will package includes a will. It can be simple or complex depending on what your circumstances are. I think it's very important that for me to meet with clientele, to find exactly what their needs are, and create a estate plan specifically tailored to their needs. So we're not talking about a cookie cutter situation. We're not talking about one size fits all. We're talking about me sitting down with you, fleshing out all the important details of what's important to you in terms of how you want to divide your property, and then crafting that information into a will that works for you. But in addition to that, you also get what's called a power of attorney, a financial power of attorney, because while you're alive, there's going to be certain things in your finances you may want someone to help you handle if you're not able to do so, if you should become incapacitated. So that's where your general, or in this case, a durable financial power of attorney comes into play. But also with me, you get what's called an advanced medical directive. Now, back in 2007, before 2007, living wills used to be standalone. I mean, you'd have a living will which talked about withdrawing, withholding medical treatment, and then you would have your what was called at that time, before 2007, a durable health care power of attorney. Okay, so you had two documents, but the law was changed, and the living will statute was repealed in 2007. So now, what that statute did was, the new statute was, it combined the living will and what we used to know as the durable health care power of attorney, and combined into one document called the Advanced Health Care Directive. So for example, living wills will now be a part of, or supplemental to. You can have a living will declaration, which I've done with a number of my clients. And that living will declaration now, though it's not standalone, it becomes a part of the Advanced Medical Directive. So now it has your wishes there now in the directive regarding how you wish to handle medical treatment in an emergency, but it also handles what you're having an agent to make healthcare decisions for you.
And I would extend, so just, and I know you gave a little bit, but
Yeah.
an advanced healthcare directive.
Yes.
Tell people why that's really important.
That is so important because, again, we can any of us could face a tragedy in our lives, whether, that can incapacitate us, whether it be a car accident, a stroke, or some kind of medical event where we're no longer able to handle our affairs medically, okay? Or let's say, for example, a medical emergency may result in a coma, for example, where you're not able to, you're completely incapacitated. You have no means of being able to make any decision for yourself regarding your health care. You may not be able to communicate what your wishes are. So what the Advanced Medical Directive does is two things. One, it allows the person who has that power, who's your agent, to go to the medical personnel, say you're in the hospital, you're in a coma, and say, okay, well, if he cannot be revived, okay, here's the treatment that he is willing to receive while he's in his condition. Here's the treatment he's not willing to receive. And also, because I'm his agent for health care, before you and that being medical personnel, make a decision about what's going to happen with him or her regarding their medical care, I am the person you're going to go to make that decision, because the person who made the Advanced Healthcare Directive placed me in charge, gave me that authority to act for them as the agent to make those healthcare decisions. Very important.
The reason that I wanted him to elaborate on that is that because this is something that was near and dear to my heart, because it just recently happened to me with my mother-in-law. And with my wife as well. We have these in place. We're getting the will and everything set up. Well, actually going to look at the trust, but we'll talk about that in the second half hour of the show. But with the Advanced Medical Directive, people don't understand how huge that is. Like, one of the things that I didn't realize until I really started going to the hospital with Darlene, like, if you go to the nurses' stations, there's financial power of attorneys and all of those things right there. And I'm like, that's not the time to be trying to make those decisions, right? Like, it's kind of late. And when I talk to my clients about that, I said those things are so important, because you never say, oh, next Friday I'm gonna have a stroke and I'm not gonna be able to talk. So you never know that, right? So you say, I'll get it done Saturday, or excuse me, Thursday. You need to plan those things, because I pray and wish this on nobody, but it's one of those things that, like I always say, it's like car insurance. I'd rather you have it than and not need it, than need it and not have it.
That's correct.
Because it is so huge. Because what I tell people is, you are taking that burden off of me, and I say that because there are some people that don't want to live on life support. There's some people that say, look, if I got an ounce of life, I want you to bring me back. Don't make me make that decision for you. Tell me what you want to do. And it makes things easier, because everything I do in finances is an emotional attachment. And when you put that burden on somebody, when you pass or you leave, that's still with them. So let them at least say, I honor their wishes. You know what I mean? So that's why I think that is really so huge. Now, talk to me a little bit about the power of attorney. Are there different forms of power of attorneys that we can have and you can do?
Yes, there are. And the main difference is, well, first of all, you have, with powers of attorney, you have what's known as durable powers of attorney, as opposed to general powers of attorney. And the distinction there is that general power of attorney says pretty much, I'm giving you charge of handling certain affairs for me, okay? But as soon as I become incapacitated, you know what, that's it. Your powers stop at that point. The time I say you can't do it anymore, or the time I become incapacitated, the powers stop. And that's where the durable language comes into play. When we talk about a power of attorney being durable, what we're saying is that it lasts beyond. It has a durability. It lasts beyond your incapacity. So in a durable power of attorney, a person now gives the power to someone else, okay? And now, if they become incapacitated, even though they're in an incapacitated state, the power doesn't stop. The person holding the durable power, the agent who holds the power of attorney, can still act for the person who gave the power, even though that person's incapacitated, hence the term durable. Okay? And of course, you have the general and durable power of attorney, but also within those powers, within the durable power of attorney, it can also have what's called a springing effect. Some people may have been familiar with the term springing power of attorney, but that means that it doesn't go into effect until a certain event occurs. Okay, so that means, well, you're telling the person, before you can act on this springing power of attorney, I have to be in a coma first. I have to be incapacitated first. Now, that's something a client can do. I mean, it's certainly an option. I don't recommend it as highly as the durable, because the durable has a smooth transition, which says, hey, as soon as I become incapacitated, you take over automatically. There's no break. The problem with the spring is that you have to now have medical experts try to determine exactly what point the incapacity occurred, or if in fact you are incapacitated, to allow the person to take over the power. So it can work, and if you want to be a little more protective, you certainly can still do this. It's certainly legal to do it. But if you really want a smooth transitioning power of attorney, it's best to have the springing power in place so that person
to have the spring or the durable?
I'm sorry, the durable. I said correctly.
Okay.
To have the durable so that person can take over in a smooth transition to take over. And also within the powers of attorney, you can set forth certain things you want the person to do. For example, my power of attorney, you have maybe between 10 and 13 categories as to what the person can handle in that power of attorney. So the bank accounts, real estate transactions, credit transactions, a medical decision, whatever it may be that you want that person to handle for you in the power of attorney can be covered in the context of the power of attorney.
And we've dealt with these. I've dealt with power of attorneys in the past, and I always tell people, don't give somebody your power of attorney that you're going to make angry or you really don't trust.
Correct.
Because I know we're talking about it if you get incapacitated.
Yes.
If you get
incapacitated.
I'm sorry. Had a brain fart, y'all. But there are points and times, like if you go out of town, you can give somebody power of attorney if you have to work and you go into a real estate closing. Like, there's so many things that I talk to people that you can really give somebody power. You can give limited power of attorney. And things of that nature. But I know people that have in the military went overseas and given their spouse power of attorney and giving them full power, durable power of attorney, and then upset and anger their wife, not realizing you just giving her control over every. So we don't plan for that.
Right.
But my job, I always tell people, like, that's one of the first questions we ask. Do you have a will or a trust? And people say, well, I don't think I need it. And you're like, with all of the assets you have, you don't think you need a will or a trust?
Yeah.
And that's because, I think with us coming from New York, We know what probate's like in New York,
Yes,
right? That's
yes.
what, a 4 or 5 year. It could be a 4 or 5 year
It
process.
can be, depending. There's no set time, but it certainly there have been probate petitions in New York that have gone that long. Yes.
And like,
Yeah.
yeah. So, but here in Georgia, it's a little bit easier. But people
Yes.
don't think. They just think, oh, well, that's my wife. Everything will be left to her.
Right.
Or, and now, especially now, when we have so many blended families and
Yeah.
single parent homes, there are
Yeah.
people, there are children outside of other marriages. Those children have to be protected. And it's
Correct.
you can sit here and the wife can say whatever she wants, and she get mad after you die.
Yeah.
And if she has all the control, she
Yeah.
can say, well, all of this money is left to me.
Yeah.
Even in life insurance, I tell people you need to make sure that they're a beneficiary. If they're
That's
a
correct.
beneficiary, there's nothing that can be done.
That's correct.
And we're going to get ready because it's coming up on the half hour. So we want to get ready. Go ahead and take our break because when we come back, I want to delve really hard into the trust aspect. And I want you to explain, the difference between a trust and a
Sure.
will and things of that nature.
Sure.
So we're going to go ahead and take our first break of the night. And I just want to say, guys, if you want to call in and talk to me or Deron, the number is 770-415-2149. You would think I should know this number without having to read it by now. But 770-415-2149. Give us a call and ask Deron any questions you have about will, trust, estate planning, or anything like that. You are listening to Getting Down to Business on 108 Praise Radio, Voice in the Gospel. We'll be right back. Welcome back to Getting Down to Business with your financial lifestyle planner, Sean Bailey, and you are listening to us on 108 Praise Radio. This evening on Getting Down to Business, we have our guest, Mr. Deron Tucker, and we've been talking for the first half hour about wills and estate planning. And before we left, he brought up a good point that I really wanted to emphasize. And what he was saying was, and I've heard people say this, I don't know how we didn't touch on it. I think we did a little bit, but when you have a power of attorney, you're not just giving somebody all of your rights. Like, it can be revoked, it can be pulled back, and also talk to them a little bit. Like, if you give somebody power of attorney and they're doing you wrong and they're doing malice type things towards you, talk to them about the liability that they face on that end.
Sure. Well, everyone who's an agent under a power of attorney, Sean, has what's called a fiduciary duty to act in the best interest of the person who gave them the power. Okay, so that means if I've been given the power of attorney, I decide to do fraudulent things, tamper with bank accounts or money launder or steal money or do things that are illegal, I can be called to the carpet legally by the person who gave me the power and also by the legal authorities. So for that reason, and even after incapacity, anyone who's acting under that power has a fiduciary duty to act in the best interest of that person. So it's not a carte blanche to do whatever you want to do because someone's giving you the power of attorney. And for that reason, I try and tell my clients, you shouldn't be afraid to give the power because you can revoke that power. And if the person's not doing what they should do, if you're not able to revoke the power, they can get into a great deal of trouble legally for not acting in your best interest. So you still have control over your life. It's still you have given the power, and therefore you still control it.
Okay, well, and that's so basically what he's saying, guys, is that don't be scared of them. You can go ahead and go get you one if you need it. So now we talked about wills. Now the second part that I really want, because I talk about this a lot with my clients, talk about what is a trust and what is the difference between a will and a trust.
Okay. Well, when people talk about a trust, and a trust is simply a legal written way to hold, manage, and distribute property. That's what it is. And when we talk about trust in the general sense, you're usually talking about a living trust, trusts that are effective while you're alive and determine how you hold and manage property while you're alive, and also has provisions for distributing property after you pass away. Now, a living trust has 4 elements. The first element, of course, is a grantor or trustor, meaning the person who actually creates the trust. The second element is trust property, meaning the real property or the personal property. Remember, we talked earlier about that you actually place into the trust agreement. Okay. That is the trust res or the corpus, the trust property that goes into the trust. Thirdly, you have the trustee. The trustee is the person that actually holds, manages, and distributes the property under the trust. That is the trustee, the person in charge of handling or managing the affairs of the trust. And lastly, a trust has to have a purpose. And when we talk about a purpose for the trust, we're talking about a beneficiary. So whether it be during the course of the living trust, and, an allocation of monies or assets, or after the grantor should pass away, who actually receives the property under the trust is remaining when the grantor passes, that would be the beneficiary. So 4 elements. In terms of the differentiation between a will and a trust is primarily, a will is designed to divide and distribute property upon your passing. That is its main purpose. A living trust is designed mainly to have a benefit while you're alive, to be able to hold, manage property while you're alive, and to distribute that property once you pass away. So it's the living trust distinction has a living benefit, where the benefit of the will doesn't come into play generally until you pass away. The living trust is given birth from the moment you create it because you're managing property and holding property in that trust. But also, a living trust is a probate avoidance tool. You might recall we talked about probate earlier in terms of administering a will. Well, when you create a living trust, you avoid probate. A living trust is not a matter of public record. It's a private document, and it is a probate avoidance procedure. So you create a living trust, and many people do it to avoid probate. That's not so much as prominent here in Georgia because of the fact that probate's not as scary in Georgia. So that may not, it is a reason to form a living trust, but it may not be your primary reason. There's several other reasons which will be beyond the scope of the program we can get into at a later time. But the living trust is primarily a probate avoidance tool. It's private. It is not subject to court supervision, okay? And because you have a living trust in place, because you're not going through probate, your beneficiaries can actually receive the property a whole lot quicker than it would, in the wills process. And also, it's private because it's not a matter of public record, and it's not subject to court supervision. It's also a private document. And that's the main distinction between a living trust and a will.
And the reason I mean I think a will is definitely if you have to get something in place. The reason I like a trust a little bit better is because, as you said, everything you said, one of the things that I hear is you have more control.
Yes.
Even from the living aspect, you have more control because there are people that have living trust that they have properties in, they have, they put a lot of things and they protect, assets and things of that nature. And so when you had if you're sitting down with somebody, when would you recommend a trust over a will or vice versa?
Well, those are things that are really dependent upon the person's needs, but there are some general principles, Sean, you can look to. For example, if you're someone who is maybe not in the best health, and you're concerned you might become incapacitated soon, and because of that, there may be some frailty in your health. You're concerned about undue influence, someone taking advantage of you. That would be a reason to have a trust. If you are concerned about maybe your own spending habits or spending habits of family members, and you want to really control that estate while you're being generous and having your estate in place, that may be a reason. If you have property out of state, okay, say for example a home out of state, that may be a very good reason, because if you have property out of state and you have a living trust, and you have a will rather, and you have the will here, and you probate that here, you still will have to, in all likelihood, start a probate petition in the other state to deal with that property. If you have a living trust and place that property out of state into that living trust here in Georgia, you don't have to worry about that second proceeding, which obviously will save you time and save you money. Also, if you're someone who is living in a state, not Georgia, but say New York, or a state that is a bit arduous when it comes to dealing with probate, that of course would be an obvious reason to have a living trust. But in general, if you're someone who really wants to have real control and management over your property, you're concerned about how you manage your assets, then you definitely want to have the living trust. But also, if you're someone who is in, you or your spouse in a second marriage, and you have children from a previous marriage, that would also be a good reason to have a living trust, because you want to make sure that those children from the previous marriage are protected, and there's no possibility of say, your current spouse or somebody else exercising undue influence and, or finding ways to block you from making distributions or protecting your children from previous marriage.
One of the things that I always tell my clients is with a trust, when we talk about a trust like in death, I always say like a trust is like your wishes from the grave. You can basically say how you want things done. It's private. That's why I always gravitate and I like trust more. Now I don't go as far. I think you need something. So if you get a will, that's fine. As you said, in the state of Georgia, probate is not as difficult, but with a trust, I think it's just a lot easier, a lot smoother. Your wishes are granted, and as you said, but with a trust, I know we talked about with a will, you have to have an agent. With the trust, do you also have an agent, or what is it?
Well, that role is performed by your trustee. They are the person that is the agent. They hold and manage and ultimately will distribute the property. But the fact of the matter, Sean, in most living trusts, the majority of living trusts in the United States, the grantor, the maker of the trust, the grantor, the trustee of the trust, and the beneficiary are the same person, or in the case of a husband and wife, the same persons. So that trustee is a person acts as being the manager.
And can you change that? Is that like revocable? Can you?
That can be changed, and actually, that is also part of the fact that makes it a revocable trust. You can revoke that trust at any time that you wish while you're living. Okay. Once you pass away, the trust becomes irrevocable at that point. But while you're living, you wake up one day and you decide you're not happy with it. You can revoke it completely, or you can amend it as well with your attorney.
Once you pass away.
Yes.
So I mean, what would you say is if somebody came to you and said, "Is there a benefit of me having a living trust while I'm alive?"
Yes, because the primary reason why you have a living trust is to manage and hold property while you're alive. So again, it is primarily a property management tool while someone is living, which again, a will is not going to be able to do that, because a will is pretty much saying, well, here's what I would like to see happen after I pass away. But the effect of those decisions is not felt until you pass away. Where with the living trust, you actually have direct control on a daily basis while you're living as to how those assets are going to be controlled and handled.
one of the things, and I always, this was a story that I heard. It was not one of my clients, but it was a story in my office where basically this gentleman, pretty wealthy, he had a trust set up, and his daughter had got, basically they had property inside of the trust.
Okay.
And his daughter got married, and as a gift, he wanted to give the house to the husband and wife. And the husband and wife lived in the house for, I think it might be about 3 to 4 years, and they were making payments to the trust for the house. House is free and clear, owned by the trust. And when the husband left, he basically had, to leave because the house was in the trust. So essentially, they were paying mortgage or paying rent or whatever to the trust. But essentially it was owned by the trust. So when they split up, now the wife, that money went to the trust, benefited the trust. And now the husband leaves the house, and now the wife has the house free. Like, I didn't realize that the trust was that powerful when you can do things like that.
Yes. And that again, that's beyond the scope of our program. Because it can get very technical when it comes to divorces, but there are provisions you can put in place that pretty much say that, in the event that you are divorced, you can take away the power of that spouse now to control things that ordinarily you wouldn't be able to if you didn't. But there are special provisions, or a provision you can put into a trust to eliminate problems, if you will, with distribution post-divorce. And that's actually that's a great point you raised. And it's a bit beyond the scope of our talk today. It's going to get very technical, but that's something. If a client had that issue, and in fact, any married client of mine who had a trust, I would want to put a provision in, involving, what would happen in the event you do divorce, because it can happen. That's the reality.
Oh man, I mean,
that's the reality. It can happen.
There's billboards on 285 and 85, not saying come here and get married.
Yeah.
Saying get a divorce for 295.
Yeah.
So yeah. So you got to look at that. But I just and there are multiple types, and I know we don't want to get too deep into it, but there are multiple types of trust, right?
Yes.
Just name the most common. That a couple of the most common.
Well, of course, your revocable living trust is probably the most common, but that is a non-tax trust. That's not designed to protect taxes. That's designed to hold and manage property. So when you get into dealing with taxes and how you, if you will, reduce your tax on your estate when you pass away, that's when you get into some of the other trust vehicles. For example, you may get into your credit shelter trust, if you will.
Wait a minute now, Deron.
Yeah.
Look.
Again, even that's going to be beyond the scope of our talk. But it's just another trust. I'll kind of leave it at that.
Because people here reducing taxes, they're going to be blowing your phone up. So I don't want that. And again, it's the reason I wanted this topic is because it's educational. People don't know.
Yeah.
There are people out there that listen to our show that make a whole lot of money.
Yes.
And these are options out there that they never knew were out there to
That's
them.
correct.
That is the purpose and the origin of getting down to business to educate. So I don't want to go too in depth with that, but they're trust out there, and they can definitely call you and get more information on that.
Sure.
So,
and a couple others I'll mention. You have irrevocable life insurance trust. If you have a life insurance, if you have a great deal of assets in life insurance policies, and you're concerned about estate tax liability, that might be an option. Another very popular one is the IRA trust. If you have significant assets in an IRA, and you're maybe concerned about how those assets are going to be handled, regarding maybe creditors going after the property, the spending habits of a beneficiary you have named in the IRA, you can actually create a trust. You won't place the IRA in the trust, but it will be there as a beneficiary of trust assets. And various sub-trusts can be created within the IRA trust to handle. That's again going a bit far afield, but there can be sub-trusts created to handle those assets so that those assets are protected, and you feel more secure in how your IRA is handled as well.
And that is definitely awesome, because one of the things that you said, and I'm a big advocate for life insurance, and it leads me to the next point. Like, people get trust and they think they're done, and I think we talked about this before.
Yeah.
You're not done. You have to fund a trust.
That's correct.
Can you explain what that funding means?
Right. What funding of a trust means, Sean, is that you're taking all the assets that you intend to put into that trust is what the funding is. So, when you put something into a trust, you're pretty much talking about the majority of your valuable assets and assets are subject to probate. So, real estate, okay, bank accounts, money market funds, money market accounts, stocks, bonds, mutual funds can be placed in, collectibles, copyrights, patents, rare gems, rare stones, all these things, they're going to be funded to the trust. Now, there are pretty much two ways to fund a trust. Either you list the asset you're placing the trust on a schedule, the proper schedule in the trust, and also you will change the title of the property from where it was before, rather say, for example, in your name, into the name of the trust. And as applicable, you want to list the property in the trust, but you also want to change the title, for example, real property, from your name into the name of the trust so that you have it. But what a lot of people have to understand as well is that when you do this and you fund a trust, you may not include all your assets. Invariably, in the course of time, there may be certain things: furniture, clothing, appliances, jewelry, other incidental personal assets that won't get into the trust because you either forget or just they don't wind up in the trust. And if you pass away, and those trusts and those assets are in your name, you got to file for probate. The way you get around this, you have something called a pour over will. And so a will is not recommended to have with a trust, but I highly recommend, and to me it's a must. You must have a pour over will that is used in conjunction with the living trust. And what the pour over will does, it acts as a catch-all. So what the pour over will says is that anything that I forgot to put into my trust or didn't put into my trust before I pass away, when I pass away, the pour over will now has it. It goes into the pour over will, and the pour over will transfers those properties by law into the trust.
Okay.
So whatever I don't put into the trust directly, that's out there in terms of my property, the pour over will catches it, and then and when I pass, turns those matters over into the care of the trust. So that way you catch everything in the net.
That is good to know. Let me ask you a question. This is just something I want to ask, throwing out there. When you hear somebody say they're a trust fund baby, what does that mean?
A trust fund baby. Well, there are many parents out there, many caretakers who are very wealthy, and they want to ensure that their loved ones are protected regarding monies. And you often see this with people who have minor children. Someone's very wealthy, they've got minor children, and they will either create a living trust, a family trust, which has provisions for the children, a certain amount of money, or even in the context of a will, you can have a provision which says that when I pass away, I'm going to take certain monies and place them into trust for my, say, 10-year-old, who's now 10 years old. And now when they reach a certain age, 21, 25, whatever the age may be, they now receive the monies. Because obviously as a minor, they don't have the authority to control those funds. Or it could even be an adult who may be 25 and may be concerned about them being someone who's going to be very, not be frugal and spend the money on things and spend it wildly and not use much discretion. And even for then, you might want to put that money in trust and so it's handled, and they can't touch those monies until a certain point in time, say age 30 if they're 25, for example, or until they meet certain conditions, maybe graduating college, getting a certain degree, or say, for example, they've got a drug addiction or a substance abuse issue. You might say, well, until it's shown and proven they no longer have this issue, they don't have access to the funds in that trust. So there are a lot of things you can do in that regard. And when we talk about trust fund babies, we're talking about pretty much generally wealthy parents that make provision by trust to make sure that their children are provided for.
Yeah, I was just asking because one of the things that I tell people is like I deal with a lot of young adults that have children, and when we do life insurance, they get sizable amounts of coverage, and because they want their child taken care of. But I'll say, well, who's the beneficiary? And they'll say, well, my husband. And the husband will say, well, my wife. I say, okay, who's the contingent beneficiary? Which means if something happens to both of you guys at the same time, who's going to get this money? Like, who is going to take care of your child if you're no longer here? And it blows my mind how many of them, like, I don't know. And it's like if something happens to both of you guys at the same time, which is very, very probable because you ride in the car a lot, whatever the case may be, who would get possession of your child? So I always recommend that you get a trust and the contingent beneficiary be the trust, and then we set the trust up. And then they say, well, how do I fund it? Well, once you pass, the life insurance would then fund the trust, and then the trust would kick in, and they're just blown away. But still, even with the trust, you got to have a trustee.
Correct.
You got to have somebody that's going to be over it, and you don't want it. I always say, I think the state can do it, or you can have somebody at the bank or whatever.
Yes.
But you don't want the state, but you wanted somebody that you can trust and that'll be that. But you can set stipulations, like if you leave your child $5 million, your child is 5, you leave them $5 million. You can stipulate, okay, this amount of money, this was our income, this amount of money is going to go to to said beneficiary
Yes,
every year, and they have to show detailed records of what is being done. Da 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 da.
that's correct.
And you can get it entailed, and people don't realize the control that they can have, and that's why I
Yes.
always say, to me, a trust is your living words from the grave.
Yes, and you know, you mentioned trustees, Sean. It's very important because I recommend in a trust that you have your trustee, which could be you, but you have a successor trustee, someone who takes over in case you're not able to, or choose not to, or you're incapacitated. And also a third, or a second successor trustee, which in the case of a trust, I'd recommend it be a bank, a financial institution, a financial advisor, someone who is very skilled with monies, who can then be the catch-all, if you will. And that way, if the handling of the trust goes on for several more years, you don't have to be concerned about someone who really is not skilled financially handling those monies or handling those assets.
And it's great.
So
I'm
glad you
happy.
mentioned that.
I'm happy that you said that, because a lot of people, what they do is they'll have a part of the trust. My financial advisor has to oversee, distribute the money to this person, but
Yes.
the financial advisor has to see over, because it has to be protection and growth and things of
Yes,
that nature.
yes.
So it is, essential to have. So we're getting down to towards the end of the show. Again, an hour seems like it just flies
Flies
by.
by.
And not to get into too much details, but how affordable is a will or a trust?
It's very affordable. When people go to my website, they can see information on, for example, my rates. If they go to www.u, that's letter U, will, W-I-L-L, trust, T-R-U-S-T.com.
I'll say that for them one more time.
That is uwilltrust.com. So www.uwill, W-I-L-L, trust, T-R-U-S-T.com. That has all my information there and also my rates. And of course, all attorneys don't charge the same.
Mm-hmm.
But I'm a firm believer in being fair when it comes to rates. I believe my rates are very reasonable. And in terms of fees, you see, rates going from they run the gamut. You can see a will as low as $69 in certain places. And I don't disparage someone who wants to do that if you feel that fits your needs. But I think that, in my case, I want to make sure that it's done properly, that all the areas are covered, that you have a level of customer service which lets you know that, you are the most important client to me. I want all my clients to feel that they are the most important client. And to me, it's that one-on-one connection I have with my clients, and the desire to meet their specific needs, that is so important. A lot of times with the very, very cheap package you see basic questions that pertain to everyone. And that may be fine in terms of setting up the structure of the will, but it may not hit certain key areas that are germane or specific to your circumstances. So the value and benefit you get with working for me is that you're getting a specific estate plan that's completely tailored to your needs. And also, too, as we mentioned earlier, you're not just getting a will for that price. You go on my website, you see the rates. You're getting the will, you're getting the financial power of attorney, but you're also getting that advanced healthcare directive, which also includes living will provisions for the same rate, the same fee.
Okay, and then one of the things I want to say, and just wrapping up, I want to really say this, because again, you can go to LegalZoom, and like you said, it can be anywhere between $69 to $200 or whatever they may charge. First thing you want to notice is read the fine print. It's not actually done up by a lawyer. They're not actually lawyers that are doing it. So it's kind of a click it and forget it, or self. And I get it. There are a lot of DIYs, people out there, do-it-yourselfers, and I get it. But when it comes to the future of your family, don't you want to pay somebody that's knowledgeable and skilled in that profession? I tell a lot of people that. Like, that's just like saying, you got your auto technician or your mechanic saying, you got a problem with your heart. I cut you open for $100 and get around there and fix it. They may fix it, but wouldn't you rather have a cardiologist, or if there's something going on in your head, wouldn't you want to have a brain surgeon cutting you open? And people say you're going too dramatic. I don't think I am. You want to get somebody that's what they do, and they're going to specialize and customize something as detailed and as something as important as this. You want that detailed to you. Whereas if you go to a LegalZoom, and I've heard a lot of people do this because we help people incorporate. And I went to LegalZoom, and again, like, what'd you get? They recommended the LLC. Why? Well, that's what they you see what I'm saying? So when it comes to these things, folks, please, 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 Mr. Duran, tell them one more time where they can find you.
You can find me at www.will, trust, trust.com. I can also be reached on my direct cell line, which is 917-952-0355. And I can also be reached by email at Attorney Duran, that's Attorney Duran, at youwilltrust.com.
And Duran is spelled with one R.
That's correct, yes.
Duran is spelled. Now I want y'all to notice that 917. That's that 5-borough area code. I just want y'all to know.
That's old school
He done
New
been
York.
down. He done been down here long, but he ain't let go of his number. I'm envious because I wish I still had my.
It's like a trademark. You know?
Yeah, I
It's
remember-
part of my identity.
I was up in I lived upstate in Rockland, and when I first really was a grown up, I got my, so I never really got a 646. I think it's 646,
Yes.
718, 917.
Yeah.
I never got one. I got a 845. So I
Okay.
was like, okay, I'm a little different. But again, in wrapping up, I want to say thank you, Mr. Duran. And I want to say to everybody that's listening, all our listeners, please, please, please. If you're not talking to Duran, you're not talking to me. I say this all the time. This is the reason I connected with this brother, because he has the same like spirit as me. If you're not talking to us, talk to somebody. Talk to somebody, because these are essential things that I'm trying to educate and bring to the masses. Nobody's really having these type of conversations that you need a will, that you need a trust. Me and Duran are going to be trying to get together and doing a lot more like information sessions for clients. We're going to be inviting them out because it's so essential. And you'll be surprised at how, with me focusing on the life insurance that I focus on and my financial planning, it's essential for a financial plan. Why would we build up all of these assets and all of this wealth just to leave it to the state to get taxed and, because here's the thing, another thing he said, creditors, when you have and this is why I'm showing my hand a little bit, why I really don't like, because when you go to probate, it's public. So anybody can say, you know what, Sean owed me $10,000. Let me go put a claim in against his estate. That holds up the process. It holds up the process. Do you have to, validify that? So when you have a trust, that stuff is private. It just moves very, very smoothly. That's one of the reasons that I always fell in love with life insurance. It's private, but here nor there. We can definitely, again, if you want to reach me, again, you can please follow my Getting Down to Business page on Facebook, Getting Down to Business, and you can just follow me on Facebook, Sean Bailey. Just look me up. I appreciate everybody tuning in tonight. Again, you could have been doing anything else in the world, but you are listening to me, and for that, I'm so grateful. When I tell you, I don't usually do this, but I just want to tell you because I've just been blessed, man. When I tell you, Duran, God has been so, so good to me.
God is good
I'm
all
telling
the
you,
time.
man, I just
All
want
the
to give him
time.
glory because
Yes.
it could have been so much worse for me, but he chose me. So
Yes.
sometimes I don't know why, and I don't ask why. I just say thank you and
That's
keep
right.
it pushing. So
Right.
please, to anybody listening out there, know tonight that you're blessed and he chose you. You woke up today. You can complain about any and everything that's going on, but what does that bring? What benefit does that bring to you? What glory does that give to God that has blessed you with another day and another life? Because believe me, somebody didn't get the same gift of life that you got this morning, and somebody won't get it tomorrow. I pray as you, and Lord's will, we will talk to you guys next Thursday, Getting Down to Business on 108 Praise Radio, voicing the gospel. We love you, and we'll see you later. Bye-bye.